propriety. The police power is subject to limitations of the federal and state constitutions. Did everybody catch that? And especially to the requirements of due process. Police power is the exercise of the sovereign right of the government to promote order, safety, security, health, morals, and general welfare within constitutional limitations, right, is an essential attribute.
All right, this is a clip from a 6-hour video, the most important probably part of the whole video. You should watch the whole thing. You should take notes. You should get involved. You're going to love what you hear here. This is the most important legal action we can take right now that I've found. Take this, share this, even if you don't want to be a part of it, if you don't understand it or don't want to look into it, share this, share this, share this. Send to lawyers, send to attorneys. They need to know about this if they don't, okay? Very, very, very important. And this also explains to you real quick in the beginning how this whole thing works, how the Supreme Court cases back you up, how to fight. Watch this whole video. It's quick. I cut it for you. It's very important. Please share this. I hope you enjoy this. I hope you utilize this. I hope you get on this level because it's very important. Also, check the channel, link below for more.
Just a little bit of wisdom. You read between the lines. In other words, what is your right to life, liberty, and pursuit of happiness? What does it mean to you? Think about it. You can look at the exact words. The right of life, liberty, and pursuit of happiness. Ducky, what's that mean? I have no idea. Well, I'm telling you to start having an idea. Because when you have an idea, they got to listen. First of all, the Constitution is the supreme law of the land, right? We established that. Who said so? Marbury versus Madison, 5 U.S. 137, 1803. The Constitution of these United States is the supreme law of the land. Any law in conflict is null and void of law. Now, we know that the Constitution is supreme. We know that the right is clearly established in Shapiro versus Thompson. Can a state, arbitrarily and erroneously, convert a secured liberty, in this case the right to travel freely unencumbered, into a privilege, and issue a license and a fee for it? Obviously, we have decided that in Murdoch versus Pennsylvania, clearly, no state may convert a secured liberty into a privilege. Now, does everybody see how we plug that in? Just like on your computer, you fill in the blanks, okay? You have the court case. It says no state can convert the liberty into a privilege and issue a license and a fee for it. Well, what right are we talking about? The right to travel freely unencumbered, so you plug that in. So does the state have a right to require you to have a license for the exercise of that right? No. Does everybody see that? Now, what happens if the state requires you to have the license? Shuttlesworth versus Birmingham, Alabama. You can ignore the license and engage in the right with impunity. That means they can't punish you. Now, what happens if they pull you over? They give you the ticket. Well, you're going to go to court and you're going to fight it. You're going to file a brief. We're going to show you how to do that at a later time. We'll show you exactly what to put down there. But these are the cases you're going to be putting down on your memorandum of law as to why you have a reason to feel that you're right. First, that your constitutional right is superior to any law that they would put down. You have that right, and they can't pass a law that takes away that right. Secondly, if they do, it's unconstitutional. Thirdly, no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, you can ignore the license and the fee and engage in the right with impunity. Shuttlesworth versus Birmingham, Alabama. And since you have not willfully done anything evil, you have relied on your Constitution and on the Supreme Court decisions, you have a perfect defense to the charge of willfulness. So you could not have been charged with willfully not going and getting the license. Does everybody see that? Okay? You have a perfect defense. United States versus Bishop, 412 U.S. 346. Defines willfulness as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. Obviously, you didn't do that, did you? Because you have a perfect defense. You relied on previous decisions of the Supreme Court, Shuttlesworth and Murdoch and Marbury. You relied on your constitutional right to travel freely unencumbered, pursuant to Shapiro versus Thompson. So you have a perfect defense. So now where are we at? Your Honor, may it please the Court, I motion for dismissal with prejudice, failure to state a cause of action for which relief can be granted, and I would like to motion to dismiss, and I'd like my costs and fees for having to defend this frivolous case. Now, you have a right to collect your time for going to court, all right? You submit your bill, you submit your proposed order, you fill out your own proposed order. That makes the case go faster, and the judges kind of like that, and it intimidates the hell out of the prosecutor when you do your own order. Now, let's say, well, that's how you interpret that, sir. That's right, sir. That is how I interpret it. And 16th Am Jurisprudence, second, section 97 says that it shall be interpreted in my favor because I am the clearly intended and expressly designated beneficiary, the citizen for the protection of rights and property. See Breyers versus United States, 273 U.S. 28. Unlawful, and that deals with an unlawful search and seizure, but it also deals that it's supposed to be interpreted in favor of you, the clearly intended and expressly designated beneficiary for the protection of your rights and property. So they got to enforce it in favor of you, right? Now, Boyd versus United States comes next. The court is to protect against any encroachment of constitutionally secured liberty. It's their duty. They have no choice. They have to do it, okay? All right, in Norton versus Shelby County, an unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protections, it creates no office. It is in legal contemplation as inoperative though it had never been passed. Now, after you write all of this stuff down, you casually say, "Wherefore, Your Honor, I pray before this honorable court for your just and lawful relief. I ask that you dismiss this case with prejudice for failure to state a cause of action for which relief can be granted, and I pray the court for my just relief for having to defend this patently frivolous and spurious case, and my costs are whatever they are." You submit that on your order. I have an order. I have a proposed order, Your Honor. It's in my brief. At that point, they will turn to the prosecutor and say, "Well, Mr. Prosecutor, what do you think you'd like to do about this?" And most of the time, they're so overwhelmed at this point that they just go, "I'll go for the dismissal, Your Honor." And the judge will give them some slack. "Well, never before was a young man, not attorney, so literally overwhelmed when it comes for the prosecution, a licensed attorney." Now, it's not my goal to make attorneys look bad. My goal is to make you look good. My goal is to make you understand your Constitution. Now, if you happen to do it and you do it better than the attorney, God bless you. And God bless America. And if the attorney doesn't do his homework and prepare his case, I have no sympathy for him. Because he shouldn't have done what he was doing anyway. If he'd had any brains, he'd have pulled you aside and he'd have done what other attorneys have done to me and said, "You know, I hate going against the pro se litigant attorney." Almost always they're really, really good. And you know, I never get to find out if they're really, really good or they're really, really bad until I show up, and then it's too late. So I'm already on the diving board. And either the pool has water in it or it doesn't. And usually it doesn't. And it hurts when you hit the bottom. So, they don't like going against you people. They will not like going against you. If you halfway know what the hell you're talking about, they're going to be intimidated. And I can tell you many, many, many tales. I had this one gentleman, he didn't have any plates on his car, and they called him into the court. And he was standing in the hallway, and the prosecution said, "Would you come over here, sir? I'd like to talk to you." He came in the office, and he sat down. And this party said to the prosecutor, "What can I do for you?" The prosecutor said, "Sir?" He said, "What can I do for you?" He said, "Well, it's not what you can do for me. I'm the prosecutor. What do you want to do in this case?" "Well, I assumed there was something I could do for you. You called me in here." "Well, what do you want to do? How do you want to plead on your case?" "Well, I don't intend to plead, sir. I intend to answer in the form of a demurrer, such that I do not acquiesce to quasi-jurisdiction, because that's an issue to be brought up in my pleadings and briefs to file with the court." The guy's mouth was on the ground. He said, "Are you an attorney, sir?" He says, "No, I'm a truck driver." The guy absolutely was in a panic. I had the same gentleman, later he was working as a bricklayer, and he did the same thing. Told the prosecutor he was a bricklayer, and the guy's jaw was on the ground. See, they don't anticipate that people that are in other jobs other than theirs have any brains. And it blows their doors off when all of a sudden this bricklayer or this truck driver can come in and argue law, and all of a sudden it's like, shoot, this guy is good. I have to treat him like he's an attorney. So what did this guy do? The first thing he does out of the chute, he walks up to the judge and he tells the judge, he says, "Judge, I'm going to dismiss this case." Because he realized he was going to get hammered. And my guy says, "He can't do that. I took day off work to come over here and battle." I told him, I said, "Shut up, sit down and relax. You won. Don't say nothing. You won." And the judge broke out laughing because this guy didn't want to quit. The judge turned to me and said, "Well, evidently the prosecutor doesn't want to proceed, sir. I'm going to have to dismiss the case. He is the complainant." "Can he do that, Judge? He can't do that. I'm here to battle. I want to go. Let's do it." And the judge laughed again. He says, "Well, apparently, sir, I cannot sustain a complaint that is not properly before the court. Counsel for prosecution has entered a motion to dismiss, and I have no other option but to dismiss. Now, if you want to countersue him, that's another case." "Well, I'll do that. I'll do that." In the meantime, I told him, "Will you be quiet and submit your bill?" "Submit your bill. You won. Submit your bill for your damages. So he did. He said, well, I'll submit my bill then, Your Honor, for my costs and fees for having to defend this frivolous case. And the judge smiled, because people don't usually do that. But if you win, they are required to pay you. That's the rules. If you lose, you pay. So the bottom line is this. When you file your papers and they turn around and you get a win, make sure you got your little bill in there for your lost time from work, or any copies that you had to make, or any visits to the law library, or any what is called real and personal damages. And don't pad the account. Put down exactly what you got, because if they force you to prove it, you can get busted for perjury. So I don't recommend you shall we say, stretch the pad. I recommend you put down exactly what your costs are. Believe me, the fact that they got beats plenty enough of a sting, and the fact they got to pay a couple $100 for your lost day at work will be more of a sting. And you will get a code on your license. And the next time you get pulled over, they will just hand your license back and tell you to think about slowing down and have a nice day. Because they don't like people like you. Because you're an American. And Americans don't give up. They never surrender, and they fight. One judge told me one time, he said, you got any kind of idea how much money you cost this court today? And I said, I hope it was a bunch, Your Honor, because I hope you got to go write a whole bunch more tickets to break even. The way I figure, the more tickets you got to write, the sooner the public's going to wake up to this theft. And maybe they'll start doing something positive to stop this kind of stuff, because it's my belief they should be having masks on out there, because, I mean, if they was an honest crook, they'd be having a mask on there when they robbed the people. Okay? Well, he didn't like that answer too good, but the bottom line is he knew I was right, and after a while they realize what your goals are, and they know, hey, this is more fun than Edgewater Park, and I want to go on all the rides twice. You know what I mean? I want to hit the Wild Mouse and a whole bunch of them other rides. Let's do it. And see, when they see that, they realize there's no point. You're not going to learn anything. You're going to cost some time, money, and materials. Now the system is not profitable. Okay? So they back off. They put a code on your license. They won't bother you anymore. And everybody see we take that line down. We take the line from the Constitution. We take the line from the right. Now let's think up another right. How about the right to work? Contract your labor and your skill and your time of life as you see fit. Now, your right to work is protected by the Constitution under the First Amendment. Again, you have a right to work and contract your labor and your skill and your time of life as you see fit. I get hauled into court before the chief judge of this big court here in Oakland County. I won't give you the judge's name because he was a fair judge and a good judge, and I'm going to let him slide. But the bottom line is this. He looked just like Abe Lincoln. I mean, exactly. He was the spitting image. And he leans over the chair and he says, well, he says, it's been reported to me, son, that you don't have a license to practice law. Is that correct? And I looked up at him and I said, Judge, I'm not practicing. I know what the hell I'm doing. And the whole court broke out laughing. He said, that's pretty good. That's pretty good. I like somebody with a sense of humor. He said, but that doesn't change anything, son. You have to have a license to practice law. And I said, Your Honor, I'm an unenfranchised common law free man. I live at the common law. I am not a participant in any tontine schemes of limited liability on a joint venture for profit with an insurable interest requiring me to participate in these illegal corporate Ponzi schemes. I am just Joe Blow from Kokomo down on the street. I just live at the common law. And I have a right to work and contract my labor, my skill, and my time of life as I see fit, not as some third-party arbitrary and capricious bar association sees fit. And they had loaded the court with all these attorneys, and they were, whoa, you hear that guy? I said, Your Honor, the state of Michigan arbitrarily and erroneously converted my right to work into a privilege and issued a license and a fee for it. That's unconstitutional, Your Honor. Marbury v. Madison, 5 U.S. 137, 1803. Anything in conflict or repugnancy is null and void of law. Okay? Can you see that? Marbury v. Madison. And since the state converted my right into a privilege and issued a license and a fee for it, Murdoch v. Pennsylvania, no state may convert a secured liberty into a privilege and issue a license and a fee for it. And if they do, Shuttlesworth v. Birmingham, Alabama says I may ignore the license and the fee and engage in the right with impunity. That means you can't punish me. And U.S. v. Bishop, 412 U.S. 346, defines willfulness as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. I submit, Your Honor, I couldn't have done an evil task because I was totally following the Constitution in the U.S. Supreme Court. I would submit that prosecution counsel's burden is to prove that I did willfully and knowingly avoid a known duty or task under the law, namely to get the license. And I would submit he specifically precluded he cannot perform his task, and therefore I'd motion for dismissal with prejudice failure to state a cause of action for which relief can be granted, and I'd kind of like to collect my costs and fees for having to defend this frivolous, spurious complaint. The judge rolls back in his chair with a great big smile, and he turns to counsel for the prosecution. He says, "Whoa, Mr. Prose, what do you think we ought to do about this young gentleman?" The prosecution bounced back. "How about we honor the motion to dismiss, Your Honor?" The judge says, "Good answer, because I don't think you're ready for this kid today." And the whole court broke out laughing. An old gentleman walked up to me and he said, "Son, I just want to shake your hand and tell you, you got to have like King Kong, because you just slammed the Bar Association right into the ground. On top of that, I've been an attorney for 57 years, and I just want to shake your hand, sir, and tell you that that was one of the most magnificent arguments that I've ever had the privilege to hear in a court of law." Now, he was an honest attorney, and he realized what kind of a chain was around his ankle with this Bar Association. And these lawyers, they resent that. They really do. They're people just like you. They don't like to have any chains on them. But they hadn't had anybody quite show them how to get those chains off. And when they saw somebody do it in their own skill, with their own, with their own cards, on their own playing field, it actually impressed the hell out of them. I had several gentlemen come up and shake my hand that day. Needless to say, the case was dismissed, and I've been helping little people getting jammed for years. Every time I see some little person get jammed, I'm out there flipping that wrench. Zingy, zingy, zingy. And I flip that wrench on them so good that usually they just back off. Dr. Kevorkian was a perfect example. The poor man was just trying to help these poor people. They were jamming him every which way but loose. So what we did is we taught him a thing called quo warranto. I got a hold of his attorney and submitted all of the arguments. All right, now we're going to bring up several arguments right here. We're going to bring up police powers, and we're going to bring up quo warranto. Quo warranto is a basic right that goes back to English law, ancient English law. Okay, here it is right here. All right, quo warranto. Let's read it. Quo warranto. In Old English practice, a writ in a nature of a writ of right for the king against him who claimed or usurped any office, franchise, or liberty, to inquire by what authority he supported his claim in order to determine the right. It lay also in the case of a non-user or long neglect of a franchise. Franchise is corporation. Or misuser or abuser of a franchise, being a writ commanding the defendant to show by what warrant he exercises such a corporate franchise, having never had any grant of it, or having forfeited it by neglect or abuse. A common law writ designed to test whether a person exercising power is legally entitled to do so. An extraordinary proceeding, prerogative in nature, addressed to preventing a continued exercise of authority unlawfully asserted. Johnson versus Manhattan Railroad Company, New York, recorded at volume 289, United States, page 479. Now, it is intended to prevent exercise of powers that are not conferred by law, and is not ordinarily available to regulate the manner of exercising such power. Now, what we did, see, police powers are defined as the right of eminent domain of a state or political subdivision to enact laws for the common good and welfare. Let's pull that out. Police powers. Everybody got that? Police power, right here. Let's do police power. Right here. Police power. This is out of Black's Law Dictionary, folks. An authority conferred by the American constitutional system in the 10th Amendment, U.S. Constitution, upon the individual states and in turn delegated to the local governments, through which they are enabled to establish a special department of police, right? Such laws and regulations as tend to prevent the commission of fraud and or crime and secure generally the comfort, safety, morals, health, and prosperity of its citizens by preserving the public order and preventing a conflict of rights in the common intercourse of the citizens, and ensuring to each an uninterrupted enjoyment. Everybody get that word, enjoyment? Of all the privileges conferred upon him or her by the general laws, the Constitution, the power of the state to place restraints on personal freedoms and property rights of persons for the protection of the public safety, health, and morals, or to promotion of the public convenience and general propriety. The police power is subject to limitations of the federal and state constitutions. Did everybody catch that? And especially to the requirements of due process. Police power is the exercise of the sovereign right of the government to promote order, safety, security, health, morals, and general welfare within constitutional limitations, right, is an essential attribute. Marshall versus Kansas City, Missouri, recorded at 35 volume, Southwest 2nd, that's another reporter, Southwest 2nd, page 877, all right? Now, police powers are the right of eminent domain of a state or political subdivision to enact laws for the common good and welfare and to curb crime within constitutional limitations. And the key words in that whole thing are within constitutional limitations. And then it tells you to see the 10th Amendment. When you see the 10th Amendment, and believe it or not, you can go look up the books, and it divides the 10th Amendment real. Here, pull over here. All right. The burdens placed on the national government as a result of states' regulation, regulation of their internal affairs, save as Congress may act to remove them, constitute normal incidents of operation within the same territory of a dual system of government. And no immunity of national government from such burden is to be implied from the Constitution. All right? All right, Penn Diaries versus Milk Control Commission, all right? A Pennsylvania case, recorded at Volume 318, U.S. 261. The people of the United States residing within any state are subject to two governments, one state and the other national. But there need be no conflict between the two because the powers which one possesses, the other does not. That's United States versus Cruikshank, a very famous Supreme Court case. Excuse me. Now, we come over here. Within the area of delegated powers, expressed or implied, this amendment does not reduce the powers of the United States. That's U.S. versus Manning. Recorded at 215, Federal Supplement, that's another reporter, page 272. The Federal Union has only those powers expressly conferred on it, and those reasonably implied from powers granted, while each state has all governmental powers except such as the people by the Constitution have conferred on the United States, denied to the state or reserved to the people themselves. Anderson versus Gladden, recorded at Volume 188, Federal Supplement 666. That's a bad number. All right? It is when federal legislation attempts to confer power upon the national government that it is not within the express or implied powers given by the Constitution that the legislation becomes vulnerable to this amendment. Okay? Now, what are we talking about here? Brady Bill? Huh? They're not within their powers. They have no 10th Amendment powers to take away the Second Amendment. Does that make sense to everybody? They don't have any powers to go and take away the Second Amendment or any other amendment. The Fourth Amendment, the Fifth Amendment, nothing. And the Ninth Amendment precluded them from adding on to the Constitution in such a way that would take away the powers. So by the Ninth Amendment and the Tenth Amendment, they're totally locked out from doing a lot of the things that they do. But see, you got to know that and be able to timely exercise it. So it's very important to understand your Tenth Amendment powers. Now, when in the course of human events it becomes necessary and proper, and this is what we did. This is what we did to help out Dr. Kevorkian. We made sure that his lawyer got this knowledge. We went in there and we dug up a writ of quo warranto. A writ of quo warranto. Alright? Now, this doesn't look like much, but let me tell you something. What we're talking about doing here, see, most cities, at least in the state of Michigan, are by Public Act 230 Public Acts or Public Act 287 of Public Acts, and in every one of them there is a Rights and Powers section. Usually it's recorded at 2.2 or 3.1, and it basically says, and I quote, subject to the Constitution of the United States and the general laws of the state of Michigan, the city of, or the township of, has rights and powers too. And then it starts listing the rights and powers. Right to have a police department, right to have a fire department, right to have a city hall, right. And it starts listing all these powers. Now, the antithesis to the argument is that if they're not within the Constitution of the United States and the general laws of the state of Michigan, they don't have any rights and powers. Does that make sense to everybody? In other words, they're in violation of their corporate charter, their franchise. They promised they would be within the Constitution of the United States and the general laws of the state of Michigan. Now, a lot of people, they don't understand the power of this argument, so I want to really push this one home. I want you to understand. Whenever these little townships and these little cities and what have you, they start acting like King Farouk and that you don't matter and that they don't got to listen to you, this is what I want you to do. You ask them a pointed question and ask them, are you violating my constitutionally secured civil rights by however you claim they are? Because if you are, you have just waived your right to be the city of. And they'll laugh at you for a little bit, okay? Then you explain to them Public Act 230 of Public Acts, which states the Rights and Powers section subject to the Constitution of the United States and the general laws of the state of Michigan. You have rights and powers. The antithesis to that argument is if you're not going to be within the Constitution of the United States or the general laws of the state of Michigan and you're going to violate my constitutional rights and trample my rights, what we're going to do here is we're going to go for a writ of mandamus in quo warranto. Well, that's a legal term, fancy legal term. But it is an ancient law that goes way back to England in the ancient times. And basically here is a judgment and a capious action for it, right? You put down here the case. The case came on regularly for trial before the Honorable, and you put the judge's name in there, whatever it is, on a jury trial or non-jury trial, dated such and such. The name appeared as for your counsel, and the name appeared for opposing counsel, right? The court heard the testimony and examined the proofs offered by the parties. The court considered itself fully advised in the premise filed in its findings of fact and conclusions of law, and directed that judgments be entered in accordance with such findings, right? Which means they figured out that they violated your constitutional rights. They didn't have a right to violate your constitutional rights, and in the hearing you showed they violated your constitutional rights, and the judge figured out they violated your constitutional rights. So now, for your prayer for relief, we're going to get this quo warranto. And this is exactly what happened to the Honorable Dr. Kevorkian. You'll notice that he was in jail and they were hammering the tail out of him. The next thing you know, everything got real quiet. Nobody said nothing. And then the next thing you know, they were letting him go and they were minding their business. Now, this is how it happened. It is therefore ordered and adjudged and decreed. 1. Defendant corporation, the city of, you put down what name, has violated provisions of the act under which it was created, and also has violated provisions of Public Act 230 of Public Act Section 2.2 Rights and Powers section. In other words, it didn't uphold the Constitution of the United States or the general laws of the state of Michigan. Defendant corporation, the city of, whatever, Pontiac, whatever, accordingly has forfeited its charter and become liable to be dissolved by the abuse of its power. How much money am I talking about here, folks? We'd be in about 9 decimal places plus, wouldn't you, don't you think? Now, do you think they're going to bother some little doctor when they're looking at shutting down a major city? What do you think is going to happen? Everything's going to get quiet and they're going to let the good doctor go. Same thing for you. Now, defendant corporation, you name them, therefore is dissolved, and the corporate rights, privileges, and franchise of defendants are declared forfeited to the people. Defendant corporation, you name them, as trustees, directors, managers, and other official officers, attorneys, and agents, are forever restrained and enjoined from exercising any of the corporate franchise powers, rights, and or privileges previously exercised by defendants said city, and from collecting or receiving any debts and or demands belonging to or held by defendant city, whatever, and from paying out or in any manner interfering with, transferring, or delivering to any person any of the deposits, money, securities, property, and effects of the defendant city or held by it. You name a trustee, which the state would do, probably the Attorney General, after your complaint is filed, is appointed receiver of all of the property, real and personal things in action and effects of defendant city corporation held by and vested in defendants or in or to which defendant may be in any wise interested or entitled thereto. Plaintiff, the people of the state of whatever, that's us, state of Michigan, shall recover of defendant corporation, whatever city of, the sum of damages, real and personal. Got me? They don't like that when you start talking that because they can go 100 million 3 times that amount punitive damages. They get a little upset. As costs and disbursements of this action, and the receiver is directed to pay this sum out of their pocket to whoever the Attorney General, but you can have a person stipulated on there as an injured party. Now, you put down there, the Honorable Judge so-and-so presiding, the date entered, and he signs that, and that city is no longer a city. You see, when they violate your Constitution, this is one of the most powerful tools that you can use. And when you jam this on, you better wear a bulletproof vest to court, because you're probably going to get shot at by the time you get home. But it's nice to threaten. You just threaten. Just drop one of them in the mail and say, if I don't get reasonable cause for my action in the near future, you're going to get one of these in the mail for real. Here is a summons for quo warranto. This is for the start of the thing. Right here. Summons. Form 41. By the way, you can get this in 21 AM Juris Forms and Practice. Your practical forms and practice. Alright? You name the party, you put down there who you are, the people of the state of Michigan versus, you are summoned to appear before which and which court on such and such a date to show by what authority you claim to have, use, and or enjoy the rights and liberties enfranchised, namely the corporation city of, set out and complained of in such and such a time, summons, and further to do and receive all things which the court shall then order concerning you. This is kind of like pulling their driver's license for drunk driving. Now, that's an oversimplification, but sometimes these city halls operate like a drunken sailor. And they just think they can abuse citizens' rights and trash them. You know who I am? No, and I don't care. You know who I am? I'm your boss. I'm the people. You're elected to work for me. And I'm trying to be nice, so I'd appreciate it if we can sit down and work this out. But if we can't work this out, I'm going to sock it to you, baby. You got me?